Good afternoon, everyone. Welcome to the Appellate Division First Department. Oral arguments for today, September 4th. Hope you all had a good summer, pleasant and stress-free summer. So I think you all have been here before, so I will just, those of you who have not been here before, please just ask for the time that you actually need in order to get out the salient points of your briefs, your arguments. We are fully familiar with your arguments as we have spent the entire summer poring over your briefs. So, People v. Drizel Lucas, submitted. Portongo, and if I mispronounce your names, the names of the appellant's respondents, please, I apologize. Portongo versus New York State Urban Development.
Your Honor, for the appellants, I would request 5 minutes, one more for 21 minutes for rebuttal. Respond in 5 minutes, Your Honor.
That's it? Is somebody pro hac vice? I see 2 people standing.
Sponsor for pro hac vice.
Okay, 5, 1, and 5. Emanada versus Dongo. That matter is submitted. People v. Francisco Perez. Matter is submitted. We're doing very well so far. People v. Daryl Johnson. Submitted. Excellent. Molina v. Loft 124 Conda. You broke my pattern. I think we're good. Submitted. Davenport v. New York State Department of Finance.
What?
I'm sorry?
12 minutes and 3 for rebuttal.
Okay. Who? Well, oh, I'm sorry. Could you just remain standing? So you're the appellant. You want 12 and 3? Yeah. And you're the respondent? Okay, good. So that's 6 and 2 and 6. Excellent. Garza versus the City of New York.
Yes, 7 for appellant, 10 minutes, and 5 for vote.
For respondent, 7 minutes.
I'm sorry?
7 minutes for respondent.
727. People v. Raquan Harris. Submitted. Wythberry v. Goldman. You are? And I don't see the respondent. Did you wish time to argue against yourself? It's up to you, seriously. If you want to, there are some salient points you want to get out, you can certainly.
Sure. Why don't we do it in 12 minutes?
Okay, good. We'll do it in 4. Solo Group v. Dunia. Appellant.
Attorney for appellant, requesting 10 minutes, 5 minutes rebuttal. Attorney for respondent, 8 minutes.
626. People v. Daryl Brown.
For the appellant, Mr. Brown, I request 4 minutes of argument, 1 minute for rebuttal.
414. TH Fashion Limited versus Vince Holding.
For the appellant, I request 5 minutes.
We have a respondent. They did not request any time. Did you still wish time to argue? Okay, 3. 3 minutes. VZ versus the Archdiocese of New York.
The announce for the appellant, Your Honor, request 8 minutes for argument, 4 minutes for rebuttal.
626. And by the way, Justice Gonzalez is recused on that matter, so that if there is a tie, another judge will be vouched in as per our rules. American Pipe versus National Union.
8 minutes for argument, 2 for reply, Your Honor.
You are the appellant, yes? Respondent? 624. People v. Benjamin Ornstein, those matters will be argued together.
Yes, appellant, request 8 and 2.
826. 6 West 20th Street versus Deezer Properties, that matter is submitted. Berkeley Insurance versus Schnall, that matter is submitted. Hernandez versus Samoa, that matter is submitted. First matter for argument is Boruga versus New York State Urban Development, and you can tell me how to pronounce that correctly. Okay, so like somebody needs to go to the mic to argue. Unless you want to sit there and argue.
Thank you, Your Honor, and may it please the court. Chris Bartolomucci for appellants Schindler Elevator and Midland Elevator. The plaintiff,
So was someone requesting that you be admitted pro hac vice or no?
I have been admitted, Your Honor.
Okay, so you're just, okay. Were you making that request or that was already done, or what are we doing? Okay, excellent. Okay. Okay, thank you. You may proceed.
And thank you for allowing me to appear today. The plaintiff claims that the warning light and the warning alarm on a freight elevator failed to operate.
Address the timeliness first, since that's a preliminary issue that has to be dealt with and might be dispositive.
Of course, Your Honor. What was filed here was a motion for leave to file a motion out of time beyond the 15-day period in CPLR 4405. The motion was filed 56 days
That
after.
requires good cause, so what is the good cause here that would allow the late motion to be considered?
Your Honor, it's well established that the 15-day period may be excused or extended. Here, there was no prejudice from the delay, which was not exorbitant.
Is a standard prejudice, or is the standard that you have to show good cause? So that's why I specifically was asking what the good cause is in this case, because even in the absence of prejudice, you still have to show good cause for the delay.
Your Honor, I think good cause can cover several subsidiary factors, including lack of prejudice and the strength on the merits of the motion being presented. And in this case, there was not even any claim of prejudice, let alone any action.
Again, we keep going back to the prejudice. That the question is, what was the good cause shown for the delay? Let's take away the prejudice. What was the good cause shown for the delay?
Sure, Your Honor, here it was law office failure. There was some confusion about how the rule operates in the context of a mistrial as opposed to a verdict and judgment outcome following a trial. So that's the reason.
56 days, though? I mean, you got to be on top of your case, right? You lose a trial, you got a mistrial declared, jury's disbanded. You got 56 days to sit down and try to figure out what you're going to do next?
It was 56 days, Your
Good
Honor.
cause. I mean, the way you look at it is you can say the dog ate my appeal brief, or the dog ate my motions. Okay, that would be, yeah, that's maybe a good cause. But I haven't heard anything that even comes close to good cause.
Well, the authorities cited in our brief, Your Honor, say that there are two of the relevant factors are prejudice and the strength of the merits of the argument for a directed verdict. So granted,
Why don't you think there's prejudice here? You're waiting so long. I mean, they're experts, whatever evidence, however everything's go, people's memories start to fade again.
there's no prejudice because it didn't harm.
I'll see what your opponent has to say about that, but okay.
Well, my opponent didn't contend prejudice at any point in these proceedings. So this would be for the first time if we hear it today.
Well, that's probably because they were focused on the fact that you didn't show good cause.
Well, they did. I don't believe they argued good cause either, Your Honor. There was again, there was some confusion about how the rule operated.
So
That's the best I can.
If I were to agree with your argument, you know, wouldn't we be starting playing around with the good cause requirement? If we're starting to bring in law office failure, prejudice, all this other stuff, which doesn't really fit into a good cause analysis. So that all of a sudden, we've expanded the definition of the 15-day rule as to when you're supposed to do it. I mean, you know, why should we do that?
Your Honor, we cite a case from the Second Department called Barnes, in which the motion came in 71 days after. So we're actually shorter than
There was a
71.
basis for that.
I'm sorry.
I'm sorry.
You know, again, our argument is, and I think it's well supported by the cases we cite in our brief, that the court should consider whether there was any prejudice. The court should consider the strength of the argument. And here, we believe the argument for a directed verdict was not just strong, but very strong. There's simply no evidence from which it could be concluded that the elevator companies were on notice of any problem with the elevator, which was working fine.
Well, let me ask you on the merits. One of the obligations of the elevator company, which can't be delegated, is maintenance. And how can you be entitled to a directed verdict when there were no maintenance records showing that there was regular maintenance of the elevator before the incident?
Well, Your Honor, the question is notice. There were maintenance records.
Is it just notice? Because isn't there an obligation to to take care of those elevators.
There is indeed, Your Honor, but here, it's undisputed that there was no notice of any problem with the elevator before the incident occurred, and that it continued to operate properly after it occurred. So if the elevator didn't work properly, it was a fluke occurrence that happened only on the day that the plaintiff had his incident. And if there's been no notice to the elevator companies that there's some problem.
If there's no record that they regularly inspected or how they regularly inspected, how can we definitively know as a matter of law that if they had regularly inspected, they would not have caught some issue with the elevator?
Well, this is what is relevant, Your Honor. The record shows that the elevator was checked every day at 5 a.m. between 5 and 6
By the elevator company or by the building? Because it's the elevator company's duties, not.
by the building, which would then inform the elevator company if there were a problem. Thank you.
Good afternoon, Your Honors. My name is Sherman Kerner. I represent the respondents, Nicholas Botugno and Josephine Botugno. I just want to correct a couple of things that my adversary, my opponent
So
said.
why wasn't there good cause based on the lack of prejudice in this case? It wasn't that far off that the motion got submitted.
Well, Your Honor, the issue is that the law says 15 days, and they decided they didn't understand the law. I mean, if the court wants to accept it, that they were out-of-state attorneys who didn't understand the law trying this case, and that the statute clearly says that if you have a hung jury, the statute applies. They decided that they weren't going to apply the statute. And let me just make my first point, which is that, you know, they tried to turn this court into the trial court. They present an 83-page record that is 1/20th of the record of the trial. They also misstate the law repeatedly in their brief. For example, my opponent just said in the argument here at the podium, said that there was no notice, but that's not the standard for a full-service elevator company. The standard for a full-service elevator company is that they take reasonable care to discover and correct a condition that it ought to have found. There is no, neither in the 83 pages nor in the 2,000 pages of the real record, are there any records of maintenance records by either Midland or Schindler for the month of January 2012, which shows that they had anybody there inspecting this elevator, looking at the elevator, doing what they were supposed to do. One of the things that they were supposed to do was get on top of the cab and look at the wiring for this particular audible alarm. There is no record that they did that. If the court had the full record, it would have seen that the plaintiff's expert, Patrick Karajak, clearly stated that the failure to perform the maintenance, the failure to inspect, the failure to do what they were supposed to under the full-service contract created an issue that they were negligent. Their records consisted of saying that they had done maintenance. Nobody could tell, not even the own witnesses from Midland or Schindler could tell what actually work they had done on this elevator or for this elevator for the entire month of January 2019. Also, Your Honor, it's our position that they never made a summary judgment motion here before the trial. They couldn't convince Judge Kim to throw the case out, although they made multiple motions during the course of the trial. They couldn't convince the jury that they were correct in saying—
They tried to make a motion before Judge Cervera, and he chastised them for making that motion right when they were going to trial, something like that.
I know,
Am
Your
I
Honor.
wrong?
I know, Your Honor, but—
No, I'm just trying to flesh this out. I mean, is that correct, or am I reading another appeal?
I don't recall them making a motion for summary judgment, Your Honor. I recall them opposing. I don't recall them making a motion. They did oppose the motion by the New York State Urban Development Corporation for summary judgment. I do not recall Schindler or Midland making a motion for summary judgment. In any event, maybe
Could you
I—
address the prejudice issue? I mean, assuming we agreed, that we agreed that there was good cause for the delay, what about the prejudice issue?
Well, Your Honor, this is an old case. This has slowed down the case. The appeal has slowed down the case. I do think the court below—
Prejudice is not from the appeal. The prejudice would be from the late making of the motion. That's what we—
Yeah, I think the lower court actually handled it. The lower court, in its decision, says clearly that if they're seeking to re-argue their motions for dismissal, Judge Kim says they haven't presented it. I'll read to the extent that defendants request that the court address their motion as seeking leave to re-argue the denial of defendant's motion for a directed verdict, leave to re-argue was also denied. I also raise specifically that I don't think Judge Kim's decision is an appealable piece of paper. They made an application for leave. They made the application for leave because they were late with making their motion. The court denied their application for leave and did not address the merits, simply said, I'm denying the application for leave. Under those circumstances, I don't think Judge Kim's decision is an appealable piece of paper. In addition, Your Honor, the burden that they have to demonstrate that the Judge Kim was wrong in allowing this case to go to the jury is a very high one. Every inference has to be decided in favor of the respondent, the Patugnos. Every fact has to be interpreted in favor of the Patugnos, and they don't come close to doing this. And I just want to state for the record, I'm not necessarily an appellate counsel, but if we can take a 2,000-page record and turn it into an 83-page record as though it's AI and it's a summary of what the trial was, which in no way it does, then we've created a tremendous loophole for people to take appeals off of trials that don't provide any real basis for this court or any appellate court to reach a determination on the issues raised by the appellant or the respondent.
Thank you.
Your Honor.
Just a couple quick points,
Also,
Your
how
Honor.
do you respond to the 83 pages versus the 2,000 pages that he just made?
My first response is that this was raised in a motion to dismiss in April, and this court denied the motion in May. So I think this has been asked and answered. But it's also worth noting that the plaintiff did not object to the motion that was filed in the trial court on the ground that it failed to contain the entire trial record. And at no point did he ever file a motion to enlarge the record on appeal to include the entire trial record. If the court wants to, it can ask for the entire
Let me ask you
record.
this question. You're relying on a second department case, Barnes
Yes, Your Honor.
versus Oceanus. That reason for the court to overlook the lateness of the filing of the motion was because it was a matter of law. It was rules against perpetuities. That's why that compelled the court to grant the motion, even though it was untimely, because it was a matter of law. The rules against perpetuities, oh my God, basically undermined the trial court's decision. So that's why the second department said, you know what, for that reason, it's good. Here, I mean, you're arguing also as a matter of law that you're entitled to, you're entitled to prevail in this case. You shouldn't go back to trial. But
Correct.
just based on our questions, there's so much going on in this case here that it's not so clear. It's not like a rule against perpetuities kind of case.
Well, I think the relevant part of this case is very clear. Just 2 points here. The record shows that the elevator was checked every day by a government office. And second, there's no evidence in the record that the elevator companies had any notice that this elevator was having a problem with the warning light or alarm. And those are facts that justify a finding of no notice and a judgment for the defendants.
Thank you. Thank you both. Thank you. Davenport versus New York State Department of Finance. You may proceed.
Your Honors, this is a single issue appeal. It concerns the meaning of the term correspondence in Section 3610 of the banking law. It codifies the bank examination privilege, and that privilege acts as an exception to...
So it's they define correspondence a certain way, and that is within their purview to define the terms. Is that correct?
Sorry, in whose purview?
Is it not within their purview to determine what the term correspondence means?
No, it is not. A matter of pure statutory interpretation is a matter of law for the court to decide, and it's not an issue for deference to the agencies.
And what is that based on?
Sorry?
What, your argument, what is that based upon?
Well, I cited a number of cases that say that pure statutory interpretations are a matter for the court and no ground for deference to agency decisions. The agency decisions, or the cases that the agency cites, involve a different type of situation. That's just their interpretation of the law that they're implementing, and they interpret that in the public interest. In this case, though, it goes directly to the powers of the agencies itself. So it's not an interpretation purely in the public interest, but it's a self-interested interpretation, which basically gives the agency carte blanche to withhold any documents it wants to hold. And
You seek access to documents that were submitted by Deutsche Bank
yes,
to the Department of Financial Services in connection with a money laundering investigation. Isn't that protected by statute? Isn't that protected by Banking Law 3610?
that is the bank examination privilege that the DFS invoked. It is not protected. Whether it is protected entirely depends on the meaning of the term correspondence.
Now, how do you define correspondence then?
Well, we
Well,
submitted.
that was my question. I thought that it was up to the agency to define
It's
correspondence.
not up to the agency.
How would you define it?
It is first and foremost a matter. Matter of statutory interpretation is the plain meaning of the word correspondence, the plain meaning of the statute. We submitted. We refer to 5 dictionary meanings. These are all the standard dictionaries.
Counsel, this case has to do with how they handle investigations and how they investigate banks. So when it has to do with such an important decision-making aspect of the way they run their agency, why isn't that the kind of case where you would give deference to the agency's interpretation? Because they're interpreting how they are going to handle investigations and how they think confidentiality should be handled in these investigations.
Well, I don't disagree that decision-making, anything that reflects the opinions of the DFS, strategy, deliberations, internal deliberations are subject to the bank examination privilege. We are talking here not about any internal deliberations.
But it's their interpretation of how they believe the statute should be read in order to foster these types of very sensitive investigations.
With all respect, it doesn't matter. The plain meaning of the statute is what matters.
Okay,
The
so that-
correspondence,
Talking about the plain meaning of the statute.
it is defined
Let's see,
as.
counsel, you have to wait for us to ask your question.
So talk about the meaning of the statute, right? Let's look at the statute. You have the Public Officers Law, which provides for shall disclose whatever in there in terms of investigations, disciplinary, all hosts of things that the Public Officer Law, Section 89 or 87, sets forth, saying shall produce, shall produce, shall produce. That's the default.
Yes.
But as my colleague pointed out, the banking law takes the opposite, shall not produce unless the superintendent says it's okay. So how do you reconcile the word? One statute says, yeah, the default is to produce, but the other statute is the default is not to produce. How does that work?
Well, the other side
It's
has
a big
argued
deal.
there is no conflict between the.
Well,
So let's then talk about
I would like
Public
to-
Officers Law, Section 87 2A, which applies where FOIL exemptions, where there is a specific exemption by statute, by state or federal statute. Again, going back to Banking Law 3610, it says that whether or not such information, reports, examinations of investigations, correspondence, memoranda concerning or arising out of such investigation or examination shall not be subject to subpoena and shall not be made public unless in the judgment of the superintendent, the ends of justice that the public are advanced by their publication. So we keep going in a circle, aren't we? The issue is the confidentiality that attaches to investigations where disclosure of documents could perhaps, jeopardize another investigation or jeopardize internal information that could affect the financial standing of the different entities involved. Would you disagree with that?
I would disagree with that. The confidentiality does not attach to investigations. It attaches only to three categories: reports of investigations, correspondence, and memoranda. And they need to have been created in connection with an investigation. These are documents
Says
that are
who?
created in the ordinary.
Says, wait.
That's what the statute
Documents
says.
created in connection with the investigation
it's arising out of-
or documents concerning or arising out of such investigation.
Yes.
You're adding an element that's not there.
Well, these documents were created in the ordinary course of business of the bank. They were not created in connection with any investigation.
You have time on rebuttal.
Thank you.
Good afternoon, Your Honors, and may it please the court. Grace Sow for the state respondents. This court,
Why is this a case where we should give deference to the agency's interpretation versus not giving deference? What makes this a case where the agency's interpretation is entitled to deference?
sure, Your Honor. So DFS's investigations, particularly into money laundering, are highly complex. They often span multiple years, and they involve the exchange of information in multiple forms. Therefore, the agency is best positioned to determine what scope of protections is most appropriate to safeguard highly sensitive financial
You
information.
also have third-party financial information going back and forth too in that investigation, right? People that don't know that their information is going back and forth in an investigation, correct?
That's exactly right.
Got
and
all these bank holders, these businesses, they got lots of money in there, and then they don't have an inkling that they're part of an investigation.
That's precisely right, Your Honor, and it really highlights the sensitive and confidential nature of the documents that this FOIL request seeks. So the agency is really best positioned to interpret the proper scope of protections in order to give effect to the statute's purpose of preserving confidentiality of these highly sensitive
Counsel,
documents.
in your papers, you cite the case New York Civil Liberties Union versus New York City Police Department. In that case, the documents that were sought were submitted in camera to the court for the court to review and see. Why couldn't that be done here?
So this is a FOIL case, Your Honor, and it's really different from cases in which this privilege is sometimes invoked in civil discovery or other contexts. There's no opportunity here for the state to claim partial redactions with respect to this particular exemption. There's no opportunity to seek a protective order. There's no opportunity to make arguments about the need for relevancy or proportionality, and that's precisely why FOIL is not the correct context in which to seek these documents.
What do you mean by there's no opportunity? Could that not be done if, in fact, the documents were submitted for an in-camera inspection and the court decided, well, portions should be turned over and portions should not be turned over? Could the documents not be redacted accordingly?
So when this exception applies, when Public Officers Law 87-2A applies, it allows the agency to withhold the documents as a whole. And the reason is because we're really talking about, as Justice Owing mentioned, highly sensitive
The other thing is that, 87, the default is to produce. So that's where you would have an in-camera situation, right? Because the default is you got to produce all these documents and you have to demonstrate a reasonable basis to not produce them, and that's where the in-camera comes in. Whereas banking law, the default is not to produce. I don't have to produce anything under the banking law because it is up to the superintendent. So there wouldn't be an opportunity at that point to have an in-camera proceeding, right? I mean, in-camera, I would think you would need it when you're directed to produce it, and you're like, I can't produce it. Well, let me take a look at it, right? I mean, that's the way I look at it. You got two statutes that are very different in terms of the production responsibility. Well, let me ask you this question. What is the purpose of FOIL overall? Why do we have FOIL? Is that for transparency purposes, to make sure agencies are, everything is out in the open, there's no hiding of anything, correct?
That's correct. And in this case,
So let me ask you this. This question, this FOIL proceeding, this ask that they're making, I looked at the petition, and one thing that really struck out to me on this petition that I just couldn't help get over, and that was petition paragraph 9, which he says the disclosure of these records that he's looking for is critical to petitioner's pending litigation in Denmark. Since when is FOIL used to help someone litigate? I'm not so sure that's the purpose of FOIL, is it?
it is not, Your Honor, and that's precisely another reason why FOIL should not be used in this context in order to obtain documents for use in a separate litigation. And I think that The pending federal proceedings here highlights exactly why disclosure pursuant to FOIL, which is to the public at large, with no protective order, with no restrictions on its use, is particularly inappropriate.
So Counsel, I just wanted to get back to my question. There is nothing, however, which would preclude an in-camera inspection of the documents and ultimate redaction if that was what the court decided. Is that correct?
So I think, to go to Justice Owing's point, when it comes to FOIL, and especially when it comes to, actually in this case it involves Banking Law 3610, the presumption is against the disclosure of any documents. So we
No,
don't
I
think-
understand all of that. My question is there anything that would preclude a remand to the trial court, to the motion court, for an in-camera inspection of the documents in question? Is there anything that precludes that?
So I think in this case, if the court disagrees with our reading of Banking Law 3610, the proper course is to remit to the trial court to determine whether any of the other exceptions
Yes.
apply.
That was my question, yes.
But
Counsel,
here,
let me ask you about your adversary's request for an index of the documents that are being withheld. How does that affect confidentiality? How does that affect compliance with the statute? There's nothing that says that the agency must provide an index or not. So what's your position?
our position is that an index is not required under these circumstances, and when the presumption is that these documents should be withheld as a whole, that they would absolutely harm the interests of confidentiality.
How does the creation of an index harm or affect confidentiality?
So I think that an index would still identify or give some information as to the documents that are withheld. And really, I'd like to emphasize here that the statute protects against the exchange of communications, the highly sensitive information that is exchanged between DFS and a regulated entity. And here it is in the context of a money laundering investigation. And so the interests of the statute weigh heavily in favor of DFS's reading to preclude the disclosure of these highly sensitive documents.
Thank you.
Thank you.
I still need to answer two questions Your Honor asked me.
My question about the FOIL, the purpose of the FOIL and the purpose of why
Yes.
you're seeking all this discovery.
So just 2
Not to
points.
help you with your lawsuit. That's not, there are plenty of other CPLR provisions for that. Devices.
If I may, I would like to answer your first question. The meaning of correspondence is letters or emails. That's what the dictionary says. And document productions are not letters or emails, and that's period. We need to go with the ordinary meaning of the statute. That's the legislator chose the word
Okay, let's say I
correspondence.
buy that. What's your response to my question about the FOIL, the purpose, and what you're looking at?
The case law is very clear that a petitioner does not need to state the reasons why he files a FOIL request.
That's correct.
Transparency. It doesn't matter what I need it for.
That's correct. But you put it in your petition why you need it. So I can't ignore what you're saying, that you're using it to further litigation in Denmark. I mean,
It has to do with the issue that's not on appeal, but was an issue down below, which is that
don't you
there
think
needs to
if
be
I were
balancing of public
don't you
interest.
think if I were to agree with you,
Sorry?
if I were to agree with your position here, would I be opening up the floodgates to all litigants to seek FOIL requests from all agencies who are actively investigating something so that they can pursue their lawsuits without going through the normal discovery process?
There are many exceptions to FOIL, and many can apply to withhold FOIL requests. And yes, we are allowed to request disclosure on the FOIL. I can't help that. That's the
I'm not disputing that. I'm just saying the purpose of your request is kind of, it raises an alarm for me, that's all.
I hear what you're saying, but the law is what the law says. And it says correspondence is your only exception. This is not correspondence. And the argument by the DFS that the legislator has somehow overruled your case, the Stratford case in 1960, there is no evidence for that whatsoever. So we have to, if not following the statute, we still have to follow Stratford.
Thank you. Thank you both. Garza versus the City of New York. You may proceed.
Thank you, Your Honor. On November 2nd, 2016,
Your appearance, counsel, if you would.
oh, sorry, Keegan Steffen, Belduck, Levine, Hoffman for appellant. On November 2nd, 2016.
We're familiar with the case. What I would love for you to talk about is the issue of qualified immunity.
Sure. On the issue of qualified immunity, the first prong is objective reasonableness, which I believe is, what the bulk of this case was about below.
I'm sorry, which what?
What the bulk of this case was about below. The summary judgment decision ruled that the officers acted objectively reasonable, and that was why he granted summary judgment. We obviously disagree with that for the reasons we stated in our brief. I believe you're asking about the clearly established law aspect, is that right?
Whatever you want to say about qualified immunity.
Sure. On the issue, sure. So for objective reasonableness, I think it is clear from our briefing that we believe, precedent is clear that the officer's actions have to be analyzed both for a Fourth Amendment purpose and for qualified immunity purpose under the facts most favorable to the plaintiff. And that is not what happened here below. For example, the trial court adopted a fact that was even in dispute among defendants, that a knife was on the table. One officer, Officer Biondo, said that it was. Officer Melrose said that it wasn't, and the diagram...
Let's say we only look at the undisputed facts.
Sure.
What is your best argument as to why qualified immunity does not apply to be able to grant the city summary judgment in this case?
Sure.
Assuming only undisputed facts.
Of course, Your Honor. So taking out all disputed facts, I would point out that we dispute the fact that Ariel approached the officers, that Ariel raised a Tabasco bottle over his head. So for the first tasing, Ariel was not a threat to anyone. Under those facts, it has been clearly established since 2010 that you have the right not to be tased.
What's the basis in the record that he didn't have the bottle raised up? Didn't all the testimony in the case support, at a minimum, that he had the bottle in his hand?
All of the officers said that he had a Tabasco bottle over his head. However, the diagram of the room showed the Tabasco bottle was found at least 17 feet away and in another room around a corner and unbroken. So from that, I believe a reasonable jury could find that testimony was false. And I think that ability...
Was the decedent asked at any point to put the bottle down, and in that instance, was the bottle kicked away or pushed away by the police officers?
So according to the officers, he had the bottle at one point, was asked to put it down, but then raised it again. Then after he was tased, he dropped it and it was kicked into another room. However, I do believe that from the evidence, a reasonable jury could find that these officers are just not telling the truth, that that's self-serving testimony, that this never happened. They're especially allowed to do that under noseworthy, which allows them to disbelieve testimony, even if unrefuted, if it's coming from someone who killed the opposing party, which is what happened here. They're also allowed to hold the party who is deceased to a lower standard of proof. So again, accepting all of the facts in plaintiff's favor, he wasn't a threat to the officers at that moment in any way, shape, or form. Under those sets of facts, it's been clear since at least 2010 that you have a right not to be tased. So that's the first tasing. As to the second tasings, he was on the ground, struggling to breathe. This is a disputed fact, so again, must be construed in plaintiff's favor at this juncture. He, according to the officers, again, which is the only testimony available right now, he had his hand underneath himself and was thrashing. The officers say that that was resisting. However, that could also be construed in the light most favorable to plaintiff as him struggling to breathe. And that was in fact confirmed when he turned blue after the third tasing and then died of his asphyxia. So again,
So I just want to make sure. By the time the first tase happens, he doesn't have the bottle in his hand originally. He had already put it down, correct? There are three police officers. They ascertain no one else is in the apartment, correct?
Correct.
And they ascertain that he is an EDP.
Correct.
At that point, they could have just waited for SCU, correct?
Correct.
At this point, Officer Biondo walks in with his gun out, but lowered.
Correct.
At which point, there's a dispute between the three officers as to what happens next, correct?
I'm not positive which dispute you're referring to at this juncture.
Well, as to one officer says he takes the bottle up immediately, suddenly, and tries to lunge, and the other two officers say something differently, correct?
Correct.
But at the time that the first tase happened, something else could have been done by the officers, correct?
Correct.
They could have said, put the bottle down.
Correct.
They could have stepped outside of the doorway and say, sir, we are warning you to put the bottle down, correct?
Correct.
Thank you.
But we're talking about the reasonableness of the officer's belief at the time that the decedent was tasered. So the testimony seems to be fairly consistent that at least the decedent had the bottle raised above his head and that he was screaming, and therefore could not an officer in that position reasonably conclude that the decedent or the defendant at the time was a threat and therefore taser him?
I don't believe so for a few reasons, Your Honor. First, again, it is disputed that he had the bottle and raised it, although all the officers testify to that.
They all testified that he had the bottle raised above his head. The inconsistency is whether he was lunging at the officers or whether he shot up, he was seated, whether he shot up with the bottle from the seated position to a standing position, whether he was coming at the officer.
Right. So all the officers say that he had the bottle. We believe that other evidence suggests that he did not. The officers even have a dispute among themselves about how quickly he was approaching. That leaves room for the jury to believe one officer over the other and thus believe that their threat was lower, which would change the outcome and make qualified immunity inappropriate. Would you like me to go on?
Please continue.
And so further as to the reasonableness of that, Officer Melrose, who is the officer who shot the taser, said that he moved toward. So it was not, even the officer who pulled the trigger did not say that he was lunging at him.
Well, he's moving towards him with this bottle over his head screaming. So again, would it not be reasonable for the officer at that point in time to believe that there was a threat to him and to his fellow officers?
Well, he moved toward, no indication that he's lunging, so I do believe that it would have been reasonable to just back away, to step out of the apartment. He also, says that Ariel was stepping toward him, but the marks are in Ariel's side. So there is inconsistency as to that fact, too, from which a jury could just disbelieve that testimony. I think a jury would have a really easy time finding the officer's testimony incredible and finding that he was not a threat.
Thank you.
Thank you, Your Honor.
May it please the court, Jameson Davies for the respondents. I first want to talk
Counsel,
about...
if I may.
Sure.
The patrol guide at record 1265 has two sections, scope and definitions, to which I'm going to briefly refer. In the scope section, it does say that the safety of all persons involved is paramount in cases involving emotionally disturbed persons, and I jump where it's to the part which says, if the emotionally disturbed person is armed or violent, no attempt will be made to take the EDP into custody without the specific direction of a supervisor unless there is an immediate threat of physical harm to the EDP or others are present. If an EDP is not immediately dangerous and immediately is underlined, the person should be contained until assistance arrives. It goes on in the definitions section, which is right underneath zone of safety, the distance to be maintained between the EDP and the responding member of the service. This distance should be greater than the effective range of the weapon. To the extent that there is a discrepancy amongst the officers in regard to the movements of the EDP, the decedent, in this case, would you agree that there is a triable issue of fact as to whether or not there was an immediate threat of physical harm to the EDP or others within the scope, the definitions provided by the patrol guide?
A couple of points on there, Your Honor. I think, as we point out in our brief, a violation of the patrol guide is not the same thing as objective reasonableness. If you look at Salim, they say even if there's a violation of police procedure, even if you could disengage and you fail to do so, that just doesn't go into the effect.
Let's assume that we agree that this is not a mandate, but rather a guidance, which is why it's called patrol guide, not the law, right? So please continue.
Right. So, so what I'm saying is, under the law, under the objective reasonableness standard, whether or not there was a pre-existing violation of the patrol guide just doesn't factor into the analysis. The analysis is independent of any.
But there is a question, given the discrepancy amongst the officers, is there not, as to whether or not there was an immediate threat to either the EDP or the officers themselves?
Well, that's the second point I wanted to get into, because the entire issue about whether there's a disputed issue of fact, this is from a record 1332. This is from the plaintiff's statement of facts. When Officer Biondo was a few feet away and Mr. Galarza holding a firearm, and Sergeant Melrose also a few feet away from Mr. Galarza and holding a taser, Mr. Galarza stood up, grabbed a bottle of Tabasco sauce, and raised it over his head while screaming. That's from the plaintiff's statement of facts. So at this point, they cannot now claim that there's a disputed issue of fact as any of these, whether or not the bottle was raised, whether or not he approached the officer, because they conceded that in their issue of fact. This isn't an issue of, as they put in their rebuttal, in their reply papers, it's not a preservation issue. It's an issue of, you can't make affirmative representations of facts in your statement of material facts, and then when that doesn't work out on appeal, make an entirely new case about different issues of fact that you conceded below. So if I could also turn to the point of qualified immunity. I think we went on the objective and reasonableness prong already, but they don't point to any specific cases that hold that this specific use of force was objectively unreasonable, and they have to point to some controlling authority. And if you look at page 18 of our brief, we cite a number of cases where taser use in much less risky circumstances was found to be objectively reasonable.
Is there a consistency as to the testimony of the police officers with respect to what the decedent did with the bottle? In other words, did he move forward? Did he stand still? Or are they all uniform in saying that he lunged forward?
I don't know that they all use the term lunge. I think it's a semantic distinction, but I think the testimony is consistent among all the officers, and I think that's why the plaintiff conceded it in their own statement of material facts, that he stood up, moved towards the officers, raised the bottle over his head while screaming. I think even if there wasn't a bottle, that movement towards the officers, we cite a case saying, within a few feet, that's close enough distance, there could be a threat, and you're justified in using non-lethal force in response to that threat, even in much less serious circumstances, like I was saying before.
So your position is it doesn't matter that he was obviously an EDP, and therefore there should have been a difference in the way he was approached and the way in which he was engaged?
I think that doesn't matter in the terms of analyzing Fourth Amendment objective reasonableness. That nothing about those standards, the patrol guide standard, is incorporated into any court's analysis of objective reasonableness of the use of force under the Fourth Amendment.
That's more along the lines of the excessive force argument, right, and those type of factors.
It could be, Your Honor, but I think it's just what is in the patrol guide just is relevant to police discipline and the governance of NYPD, but I don't think it's relevant to the analysis of unreasonable force under the Fourth Amendment and what's objectively reasonable.
And the inconsistencies in terms of whether the decedent was lunging at them or was lunging at the officer, came at the officers, or simply stood up. Again, you don't believe that that goes to the objective reasonableness of the conduct of the officers?
I think the testimony is consistent that he at least stood up, and I think that is enough to support objective reasonableness under the case law, under all the cases we cite. Even when a defendant was already handcuffed, courts have found that it's objectively reasonable to use a taser when they were just using it when someone was verbally belligerent but not physically threatening. Courts have also found that that's objectively reasonable. And that stems from the fact that it's in most circumstances, and that's what it has to be looked at, that's why it's an objective test. In most circumstances, it's going to be a non-lethal use of force. Unfortunately, it interacted with Mr. Galarza's history of drug use and his heart complications and led to an unfortunate result in this circumstance, but the test is an objective one. And all the cases we cite show that that's an objectively reasonable use of force, regardless of the
So
facts.
all of us are aware that police officers have to make decisions in the blink of an eye in order to protect themselves and others, right? But to the extent that, for example, the guide says that upon arrival at the scene, in assessing the threat, take cover, utilize protective shield if available, and request additional personnel if necessary. Could the officers have stepped back in the event that the decedent posed a threat to them?
Two responses to that, if
Because
I may.
they used a taser once and a second time, and then the third time, it went into, what is that
Drive
high
stun
level
mode.
called?
Drive stun mode, I believe.
That's the worst level, right?
It's the most
It's the one that
painful, but
puts
it's less likely to cause permanent damage.
It's the one that sticks little jabs in you, right?
Correct. Yeah, it's more painful, but less likely to cause permanent damage. But two responses, if I may, to that,
Please.
Your Honor. First, I think it's important to note that this entire encounter happened within the span of less than 3 minutes, so it's really fast-acting, fast-evolving situation. And then my second point is, I think, just look at Salim, which we cite, which says that even if there was some violation of procedure, even if there was a failure to disengage when the opportunity presented itself, that does not render the use of force objectively unreasonable.
Thank you.
Thank you, Your Honor. So we urge affirmance.
So, counsel, to the extent that a manual or a guide is not dispositive in determining reasonableness, does it have any weight?
Yes, I believe so, Your Honor. While it's not case law, it does give officers fair notice about what is reasonable and what is not reasonable. I mean, that's the reason that the defendant's own expert relies on it extensively. It's often very coextensive with the law as it stands.
So what I gather from your adversary's argument is that there are two components here. One, for the qualified immunity, is basically, you have to look at it's objectively reasonable what the officers did, okay? And a lot of the factors that we're being bandied about doesn't come into play to make that determination, but would be more fitting for the excessive force claim. Do you disagree, or do you agree or disagree with that analysis or that sort of
I disagree with that
dichotomy?
characterization. The heart of an excessive force claim is objective reasonableness. And that's...
Yeah, but when talking about qualified immunity versus excessive force, he started compartmentalizing it. What ingredients you need for one may not be the same ingredients that you're going to need for the other.
Well, the objective reasonableness standard is quite similar, if not identical, on both for the Fourth Amendment claim and for
He points to the case where the individual was already restrained, he was handcuffed, and he still got tased.
Right. I strongly believe that those are all wild mischaracterizations of those cases. For example, Pacheco, he was attacking the EMTs. He was kicking people so violently, he smashed a dresser. He bit an officer so hard he broke his skin. Even though he was restrained, he was still doing all of that. Crowell is an unpublished case, and it was okay to tase because other protesters were quickly approaching, so they had to deal with the situation rapidly. Way distinct from this case. In McLeod, another unpublished case, this was a high-speed chase. He nearly sideswiped an officer, and the court relied on the fact that there was an extremely serious crime that had just been committed, which is not the case here, and the officers were reasonably concerned that the suspect would violently lash out again. In Draper, the whole incident is caught on film. The officer and the suspect are in close quarters behind the car. The officer repeatedly...
So it's not simply just taking the ingredients for one. They kind of just flow back and forth. They're not, you can't compartmentalize them, right? That's basically, I'm hearing that's what you're arguing, right?
Right. I mean, for objective reasonableness, the Graham factors need to be considered. And in all of these cases, the Graham factors weigh far more in favor of force being used than they do here. No officer could look at these cases and believe that the use of force in this case was objectively reasonable. There was significantly less reason to use force, and yet they used force until he died.
Thank you. Thank you both. Wife Barry v. Goldman. I only had an appellant. Did I miss it?
We have only appellant, no respondent.
Oh, you're both together?
Yes.
Oh, okay, thank you. You may proceed.
Good afternoon, Your Honor. I'm Vel Friedman here for the appellants. Your Honor, in reality, this petition presents a very narrow issue, which is, can Goldman, the respondent, force the companies, the petitioners, into a multi-million-dollar arbitration that this court, or a separate panel of this court, has already stayed? The companies say no, because they have not executed an arbitration agreement, and Goldman says yes by attempting to use two different agreements and daisy-chaining them together. He takes what we call the side agreement. He says the side agreement incorporates an arbitration clause from the Fifth Amendment, and that Fifth Amendment requires all the companies to arbitrate. Now, he's wrong for two reasons. The first is...
He's relying on the side agreement, right? Mr. Goldman is relying on the side agreement, saying that Mr. Weiss signed it on behalf of, according to the translation, on behalf of the corporation and other entities as a whole, and so forth, and therefore Mr. Goldman is saying, see, everybody's involved in this.
That's right, Justice, but the fact is, when you get down to the actual language of the side agreement, that's just not what it does.
Yeah, they're sort of like going back and forth, what does it really mean, right?
Right, and so...
I guess in the sense that if there's an ambiguity, then that's not a clear agreement to arbitrate, right?
That's right, and you need, under the New York Court of Appeals, you need unambiguous, clear, express, without any implication to arbitrate, and he just doesn't have it here. And that's why I say he's wrong for two reasons. He's wrong because the side agreement simply does not make all the obligations of the side agreement apply to the companies, and I'll show that in a minute by looking at the language. And he's wrong because even if it did, even if it took the Fifth Amendment's arbitration clause and applied it to all the companies via the side agreement, the Fifth Amendment's arbitration clause itself is restricted by its own terms to disputes under $500,000. And this dispute is agreed by the parties that it's not over $500,000. And so those two reasons are the key reasons why this arbitration against the companies cannot proceed.
So I'm going to ask you a tricky question.
Uh-oh.
All right. So the side agreement it's translated
Yes,
from
Your Honor.
Hebrew.
Yes.
And the your adversary says that the first paragraph, which references both on our behalf and on that of all the corporations registered under our names, means that everything that's in this side agreement is inclusive of all the corporations.
That is his argument.
And then in the second paragraph, there's a reference to the Fifth Amendment operating agreement, which was signed by us on said date, right? And signed by us would only mean the two individual parties because they're the only people who signed the Fifth Amendment. And similarly, this side agreement is signed only by those same two of those people, right? The next line says, in any proceeding or hearing between us, and then it goes on to talk about the arbitration, that everything would be subject to arbitration. Given the fact that this is a translation, is there any indication from the translator that the term us in Hebrew is an inclusive word? It's inclusive, meaning that once you use us, it means everybody that you begin with and everybody that you end with, because that is the import of the term us, that there is an inclusive and an exclusive use of us in the Hebrew language.
Sure. So Justice Gonzalez, because respondent didn't develop that argument, I can't answer that. They did note in their briefing that there is no dispute over the translation. So we didn't. They provided the translation. We didn't dispute it.
But there is no distinction between the how would you say it, substantiated or offered by the translator with respect to how the word us can be used. Is that right?
That's correct. There's nothing in the record to show that that us is different than any other us.
Thank you very much. Solo Group versus Dunia. You may proceed.
Thank you. This appeal is brought today pertaining to Rappel 1301 Subdivision 3.
Counsel, why don't you start with the mootness issue and what your argument as to why this case is not moot, since no stay was obtained of the foreclosure sale and the property was sold to a good faith purchaser. So since there was no stay of the judgment, what is left now to be determined?
Absolutely. Upon first reading respondents' motions, that was certainly something that jumped out at me. It was new case law that I saw, and upon an investigation of the case law, it seems to only limit a remedy of the defendant to potentially basically getting the property back. But they're still unavailable to sue for the actual cost of the house. There's no prohibition, there's no requirement that a defendant, in order to actually have an appeal, must first stay in action.
But isn't what you're ultimately seeking in this particular action to undo the granting of summary judgment, which was to allow an order of reference and a sale of the property? So the purpose of the underlying action was to get a foreclosure judgment. That foreclosure has happened, the property has been sold. So in the context of this foreclosure action, what else is left?
Well, we're entitled to the value of the property in a lawsuit.
That's not one of the causes of action in this lawsuit. This is on its face a foreclosure action, which already has gone to summary judgment, order of reference, and sale. I don't know if there's some other action for you to bring. I'm not going to comment on that, but that's not what this action is.
I would submit that to look at it that way is to put, respectfully, the cart before the horse. The argument here is that this case was dismissed by operation of law prior to summary judgment, prior to the judgment of foreclosure and sale. Now, if it was dismissed by operation of law, the action was terminated. Any judgments that were rendered after that were without effect as a jurisdictional defect because the case wasn't reopened. There wasn't an application to reopen. The court certainly can't do so sua sponte, even if it's
You're relying on the Foreclosure Act, Abuse and Prevention Act, right?
No, I'm
arguing, no?
Well, I am not
where
in
you're coming
this
from.
particular principle, which is more. It's more of
You're saying because the other two actions were commenced after this action should have been dismissed as a matter of law, right?
correct, by operation of law.
By operation of law. So that's the Foreclosure and Abuse and Prevention Act. That gives you that opportunity. But that got passed in, my note says in 2022, way after these actions were even commenced. And then in addition, the two actions in 2016, they were discontinued or dismissed. So that leaves the 2008 still alive, right?
So I would make 2 points to that. The first point, of course, being that this court has held that FAPA is, of course, retroactive. And so, but further, it would also submit
Sorry, say that again?
that
There
this,
hasn't been a judgment yet, not a case like, we've never held it retroactive in a situation such as this, where the judgment has been obtained and the property has been sold. Those are cases where the action's still going on and there hasn't been a sale of the property.
once again, once we look to the jurisdictional of, once the plaintiff brought a plenary action with an active case, and I would submit also that CPLR 1301 existed prior to the commencement of this action.
My concern here is that we're dealing with, I think in my mind, we're dealing with two situations. One is we have the foreclosure action itself, and then second, it's the judgment that actually sells the property. The action's already done. Once the judgment gets entered for the property being sold, right, that's it. So what happens next, as my colleague said, that's up to you guys, but in terms of the foreclosure action, and this appeal is related to the foreclosure action, that's buried, that's gone. There's nothing left to do there.
That would presume that the order had effect and that it was not void
Well, it
when
had
issued.
effect because the property was sold, it's done.
Once again,
There's no extant cause of action in this case for you to get the value of the house. You've never asserted a claim for the value of the house. This whole case was litigated in the context of a foreclosure action. What you're talking about here is a completely different thing, which I've never seen, but I've never ever seen it, but it's not even what was litigated in this case. So bringing this case alive wouldn't bring back that claim alive because there was never a claim asserted by your client in this case for the value of the property once valid foreclosure went through. It's a whole different claim.
And the flip side of that is that your argument is that the 2008 action was gone as a matter of law because you had subsequent commenced actions. Well, those subsequent commenced actions in themselves were gone. They're gone. So that, in a sense, there had to be an action still left, right?
No.
So counsel,
Counsel, but I'm sorry.
doesn't the pendency of an earlier filed case generally require dismissal of a later filed case? In other words, if the 2008 case was alive and well and the 2015 case was alive and well, under normal circumstances, wouldn't the 2015 case kind of have to get dismissed unless in other words, the 2008 case is alive no matter what?
So this appeal is about if, is a specific argument, which is clearly being, I think everyone has a pretty good grasp of, that once the 09 case was commenced, by operation of law, the 2008 case was discontinued.
Says who?
Says the statute. Now, the statute did exist
Which
prior.
statute?
The Repeal 1301, Subdivision 3, which existed prior to the commencement of the 08 case, commenced prior to the 09 case. And as this court has held, that FAPA is retroactive. Obviously, the statute existed at the time, but I don't think that the courts were giving it the type of teeth that it should have had. And we see that each time that this application...
Didn't Mr. Dunia enter a step with Solo to discontinue the 2015 action? Because the 2008 action was brought back? Wasn't that your client that entered that step?
Yes, Your Honor. Well, respectfully, I think that respondent makes a very good argument that it wasn't necessarily the 2015 action. That was the plenary action that was on point because it was commenced when the 08 case was temporarily dismissed. But the issue here is the 09 case. And the 09 case wasn't on consent. That was dismissed for abandonment, which goes back to the Court of Appeals decision, which states that this law is here to protect my client from duplicitous litigation. We don't need 3 cases. We only need 2 for this to be applicable. And that case from the Court of Appeals predated FAPA. Our position is effectively that this would have had to have been denied with a pre-FAPA review, and that FAPA is simply clarifying longstanding law that existed at the time. So, when I first looked at this, I told the client, I can't help you. But when I took a closer look and I paid a little bit more attention, I realized that this really is the controlling, that it was dismissed. And once it was deemed dismissed by operation of law, it was terminated. And unless there's a court order reopening the case, any order from the court is without effect. And to put a finer point on that...
I'm going to ask you just one question. You can say yes or no. Do they have the same index numbers?
No.
Okay. That's all I needed to
By
know.
they...
You have time on me, Bottom.
Thank you.
May it please the court, Ryan Matola of counsel for Valet Law for the plaintiff respondent. I want to first address the motion to dismiss and the mootness issue. I think FAPA in and of itself resolves that issue under Section 10 of FAPA. Section 10 of FAPA says that it applies except in circumstances where the judgment has been enforced.
Right.
The judgment has been enforced.
That's what was stated. So that's what I'm not understanding. The judgment was already enforced. The property has been sold. It's a foreclosure action. So I'm not understanding how there would be any remedy other than the cost of the home, which was not requested or sought, or can be sought in a foreclosure action.
Correct. What I would also
His main argument is, if I understand it, maybe I'm misunderstanding, is basically the 2008 action ceased to exist upon commencement of either the 2009 or 2015 action.
It sounds like
there was a step as to 2000.
It sounds like Back to the Future to me. I mean,
So we're 2009. So the 2009 still exists.
2008 still exists.
2008, right? 2008 still exists. But the property is sold.
Essentially, Let's talk about FAPA
It's a hot mess.
Yeah, it just,
Well, yeah, but you know what? You guys caused it by filing all these different actions, which I
understood.
could not understand,
Well,
you know,
let's
while you
talk
go
about-
after Dunia when you're ready. I mean,
So let's talk about that. Why did that happen? What is it in the foreclosures? Why did that all occur? Well, as stated in the statement of facts, the borrower, Harris, a couple of days after the loan closed, transferred to Dunia.
yeah.
So the action was commenced against Harris, not Dunia, which happens in foreclosure actions. And what happens? You bring a separate action. So in reality, the action number one, which is the current action, and action number two are two different actions because they're against two different people. And so they're not really the same because you're going against the owner of the right of redemption of the property or the deed owner versus a foreclosure action against the borrower. So it's really two different actions. As it relates to the third action, I agree with Your Honors that there was a stipulation, and at the time that the third action was commenced, this current action was dismissed until the appellate division overturned it. I think, when the court is talking about
This
retroactivity,
current action, meaning the 2008?
the 2008 action was dismissed at the time that the third action was commenced.
No, the 2009 action.
No, there was a 2008
2008
action,
action
which is the
was-
current action. You have then the 2009 action against Dunia.
Yes.
Then that 2009 action got dismissed
Correct.
under 3215.
Not the
got it from-
2008.
And then Dunia sought to intervene and vacate the JFS in this action way back when, and the court said, no, you can intervene, and upon intervention, dismissal. Then the plaintiff respondent appealed. There was no action pending at all. Another action was commenced, action number 3, and during that period of time, the appellate division said, no, the action that we're here to today should be, is valid, it shouldn't have been dismissed, and the parties stipulated to discontinue the third action because there only needs to be one action, and Dunia has now intervened. So at the time of that stipulation, there was only one action. At the time of this FAPA argument, there was only one action. At the time that the sale occurred and was enforced, there was only one action.
And that is the 2008 action.
That is,
This one.
that we're here to today. And the sale has already occurred, and under the legislator's terminology, enforced. This judgment has been enforced. The remedy would have been for the defendant appellant to make an application under 5519 of the CPLR, post a bond, and would have stayed. They did not do that. My client was within its right to enforce that judgment and did so. And by the way, this was the second time around. We spent about 6 years from the first judgment of foreclosure and sale that we had to wait for the appellate division to grant in 2023. So my client opted within its rights to enforce the judgment. It did. The defendant appellant did not utilize CPLR 5519 and post a bond. The judgment is enforced under the terms of FAPA that is espoused by the defendant appellant. Judgment's is been enforced. You can't enforce FAPA in that way. Thank you, Your Honors.
Thank you. So counsel, actually, that was my question. Why did you not move pursuant to 5519 for relief under 5519?
It is our position that nothing was transferred, that the court lacked jurisdiction to authorize the referee, that the referee lacked authority to sell the property. If this case was dismissed in 2009, when they commenced the plenary action without leave of court, pursuant to RPAPL 1301, which existed prior to the commencement of the 08 action, which was in effect through to today, if it was dismissed, it was not reopened. There is clear case law saying any orders from the trial court in the 2008 action, there's a jurisdictional defect. That means that the referee didn't
You
have
make an
it.
interesting point when you say it was dismissed. You know, the way I
the way I recall, you have to have an order of dismissal. If there's no, you can say the statute is not self-executing, right? With respect to the foreclosure abuse statute, it's not self-executing, so that, okay, if the 2008 action, if I were to agree with you, were in fact dismissed, you need an order to that effect. If there was no order to that effect, that 2009 action being dismissed later on, guess what? The 2008 action is still alive and well. It's still on someone's docket. There hasn't been an order entered dismissing it.
Well, then I would submit respectfully that this is.
Right?
Well, I would respectfully
We operate on
submit.
orders here, orders and judgments.
When we look,
balls and strikes, as they say.
when we look at the application of 1301, and we see that the court looks at it and they say, well, that earlier case was informally dismissed because of the fact that it looks like there's been nothing going on for over a year, even though there was no note of issue filed there. The court, when they saw that, when it was going against the plaintiff, all of a sudden, even though there wasn't an order, it was still informally dismissed, and that was sufficient to turn down appellate
I don't know
relief.
what an informal dismissal is.
Yeah, I don't know.
I've never, is there anything in the CPL that talks about an informal
Yes, I can go into.
You better get an order. You better get an order to give you that.
Well, if I could go in my papers, when we specifically talk about the how this court has applied 1301 in the past and how it is a perfect microcosm of what FAPA found as far as the improper application of law, we see that they're looking, petitioner makes an application. So let's see here.
I don't think the statute has been the facts that in this case fall into anything that I saw that comes up with that statute. I mean, that statute protects the defendant in a situation where there are multiple actions being commenced and they're still live. That one of these, they all can't be live. Something's got to give, right? And in this case here, that's not the concern, because whatever the statute was designed to remedy was not a problem, because you only have one action. In the end, it's the one action. And I understand what you're saying. That one action was no longer existed once the second action got commenced. But
Well, that's exactly the issue there. For instance, the most important, what we're looking at is it is the burden that's placed on the defendant. And I think that the court's losing focus on the point of 1301. 1301, specifically by the Court of Appeals, specifically held the object of the statute is to shield the mortgagor from the expense and the annoyance of two independent actions. It's respectfully submitted that once they've commenced two independent actions, we're no longer, we've lost that shield. That's a violation of that right.
But one was as to Dunia and one was as to Harris, right?
And specifically, that right goes towards an attempt to try to collect on the debt. It has no specific indication as to the party itself. And that's incredibly important to that distinction.
Thank you. Thank you both.
Thank you, Your Honor.
People v. Daryl Brown. You may proceed.
If it may please the court, on behalf of Appellant Daryl Brown, Daniel Hamburg with the Center for Appellate Litigation. Mr. Brown warrants a downward departure to a level 1 because his impressive rehabilitation, including his exceptional response to sex offender treatment and his robust family support, reflect that he is a low risk for reoffense. Contrary to the Sora Court's finding, these
I
facts...
always find it interesting when you talk about robust family support where the allegation or the conviction is for actually abusing a family member. I think that's interesting.
Well, Your Honor, the family support that is involved here is that of his wife, that of his son with special needs, and the court credited...
Didn't he have that support prior to doing what he did?
Your Honor, there's no requirement that robust family support in order to qualify...
Was it as robust at the time that he abused a child?
What I was going to say, Your Honor, is that the family support, there's no requirement that in order to be a mitigating factor not captured adequately by the risk assessment instrument, that those relationships or those connections need to be new. In fact, I think that it's reasonable to think that relationships which predate a registrant's offense and endure throughout that person's incarceration are more likely to ground them and help them progress on their path of rehabilitation once they re-enter society.
Counsel, because he had this family support when this young girl was placed in his care after she was removed from her home. And you're telling me that this support is going to be in place for him if we grant the downward departure. So what prevents him? What is the purpose of arguing the support of the family? It was there when this occurred.
Again, in order to be a mitigating factor, it does not have to be new. It does not have to be something that only arises post the offense. And in fact, in most cases, that type of family support is not going to be something that arises anew post-conviction while the registrant is incarcerated and still going to have a meaningful impact.
So you talk about a mitigating factor. His robust family support was, as a mitigating factor, was taken into consideration by the RAI. Is that correct?
No, our position is that that factor was not adequately accounted for by the RAI, and that is in line with decisions of this court as well as the Second Department that hold that family support is not a factor that is adequately accounted for by the RAI. And I'm citing here People v. Gonzalez from this court, as well as People v. Davis and People v. Teneo Morales from the Second Department.
Was not adequately considered by the RAI, or was not considered by the RAI?
Well, in order to be a mitigating factor under the RAI, it has to be a circumstance which is either of a difference in kind or degree. And so in this instance, it was not adequately accounted for by the RAI because it is a factor, it's of a different degree than is captured by simply the adequacy of one's release environment under the risk assessment instrument.
Counsel,
I'm sorry, go ahead.
I was curious about positing that the defendant's age is a mitigating factor. He was 54 years old at the time of the sexual assault of this 15-year-old girl. So, okay, so that was 7 years ago. What difference does it make at this point in time that he's 67 years old?
So, Your Honor, it's not our position that age in of itself is a separate mitigating factor. It's our position that apart from the mitigating factors that Mr. Brown established at the SORA proceeding, age which has been correlated with a lower risk of reoffense, notwithstanding the age at which the registrant initially offended, is part of the totality of the circumstances which support a downward departure, separate and apart from the legally mitigating factors under the Gelati analysis that suffice for the court to find a downward departure. At the step 3 prong of the Gelati analysis, age falls under his score on the static 9-9, a separate risk assessment instrument which is statistically validated and establishes his low risk of reoffense. So that's our position with respect to the age, not that it's in of itself.
Good afternoon, Your Honors. Elizabeth Schmidt for the people. May it please the court. Defendant was correctly adjudicated a level 2 sex offender in this case, and his downward departure application was correctly denied. The seriousness of his conduct really militates against any downward departure.
So the risk assessment was 75, right? The point assessment was 75?
That's correct,
Which is
Your Honor.
right on the cusp, right? It's 75 to, I think, 100 and something, I forget, 105. So he's right there. He accepted responsibility. He is 58 years of age now. He did tremendously well, according to your adversary, in the program. He has the custody of his a son or whatever who has special needs. His wife/fiance, we're not sure of the relationship, wrote glowing letters concerning his what he does and everything else. So why not a downward departure in this case?
Your Honor, I'd just like to mention briefly that his response to sex offender treatment certainly was not exceptional. The best reviews he received during that treatment program stated merely that he was performing to program standards. That's not an exceptional response to treatment. But beyond that, again, the seriousness of this offense really outweighs the factors that defendant has brought up in support of his application. Again, he targeted his 15-year-old granddaughter. He brazenly admitted he was attracted to her.
Two incidents, is that correct?
Yes, Your Honor. In addition to the granddaughter stating he first started staring inappropriately at her.
That was in 2017.
I believe so, Your Honor. And again, this is a really vulnerable child. She had just been removed from her mother's care, placed immediately into the care of her grandfather, who was supposed to be her guardian. She was totally reliant on him for shelter, food, along with her younger siblings. And that's very clear, too, that she had nowhere else to go at the time of this offense, because when she did report the offense, she and her siblings were removed to foster care. They had nowhere else to go. So that, in addition to targeting her while she was sleeping and defenseless, makes very clear that he was appropriately adjudicated a level 2 offender. If there are no further questions, we ask
Did
that
the court below take into account his family support?
I'm sorry, Your Honor.
Did the court below take into account his robust family support?
I believe the court did comment on his strong family support, or rather, I believe the court stated that he seemed family-oriented. So obviously that was on the court's mind, but nonetheless rejected his application.
Thank you.
Thank you.
I would just like to state, with respect to Mr. Brown's exceptional response to sex offender treatment, he received a score by DOCS evaluators of above average in every single category except for one, which is the highest possible score you can get. The one where he received a score of merely average was simply due to his difficulty communicating through writing. That plus the fact that he voluntarily reached out to a community organization in order to continue his treatment upon release, that he received maximum credit in the program. If it is possible to demonstrate an exceptional response to sex offender treatment, which the guidelines specifically contemplate that it is, yet not accounted for in the RAI, I believe that Mr. Brown has done so, indicating his rehabilitation. And I just also want to correct the record. Although the facts in the PSI indicate that there was an escalating pattern of conduct, Mr. Brown was only charged with a single incident. I don't want to have the impression that he was charged with multiple incidents that were covered under his plea. It was just a single incident.
Thank you. Thank you both. TH Fashion Limited versus Vince Holding.
Good afternoon, Your Honors. May it please the court. My name is Daniel Stujenski from Kibler, Fowler, and Cave for defendant, appellant, Vince Holding Corp. We're here to ask the court to reverse the trial court's decision that plaintiff adequately pleaded its fourth cause of action for account stated against Vince. What this claim boils down to is that plaintiff is trying to use the account stated claim as a way to impose liability on Vince for the alleged debts of its subsidiary, Rebecca Taylor. Plaintiff sued
Counsel,
both.
were all the invoices addressed to Rebecca Taylor, Inc. only? Was Vince ever named on an invoice?
All of the invoices were directed to Rebecca Taylor only. Correct.
And as to the email exchange, was there any acknowledgement by Vince that it assumed responsibility for the monies owed by Rebecca Taylor?
Never, Your Honor. The only response by someone with an @vince.com email address to the plaintiff was, this issue has been escalated and will provide a further update. That's not an acknowledgement of the debt. That's not a promise to pay. The trial court already dismissed plaintiff's attempts to assert an alter ego or corporate veil piercing theory of vicarious liability against Vince, finding that plaintiff had not adequately alleged facts to support that theory, and plaintiff hasn't appealed that decision. An account stated claim isn't a vehicle by which to try to impose a vicarious liability on a corporation's shareholders or parents, or to create liability where none otherwise exists. An account stated claim presupposes an existing contractual relationship or an existing debt, and is really just used as a means to settle the amount. Here, there was no pre-existing debt. There was no pre-existing contractual relationship between plaintiff and Vince. Any relationship was between plaintiff and Rebecca Taylor. So the account stated claim, the supposed statement of account that plaintiff submitted to the trial court is at pages 53 and 54 on the record. On its face, it says it's directed to Rebecca Taylor, Inc. So that's not a statement ever made to Vince. And that document post-dates the email chain by 9 months and doesn't match in the amount. The email chain,
The email chain saying escalation, get back to you with an update doesn't create contractual liability.
it doesn't, and there's also a discrepancy between what's alleged to be the statement of account and that email chain. The email chain, as I said, predated the statement of account by 9 months, so couldn't have acknowledged that statement of account. The email chain was regarding about $295,000 worth of Rebecca Taylor invoices. The statement of account is now about $850,000, so about $500,000 more. There's just no way that the email, whatever the email chain said, and it didn't say anything acknowledging the debt, could have related to a statement of account for a different amount that was generated 9 months later.
Thank you.
Thank you, Your Honors.
VZ versus the Archdiocese of New York. Justice Gonzalez is recused on this matter.
Good afternoon, Your Honor.
Just wait, counsel, just wait 1 second, please. Thank you.
Thank you.
You may proceed.
Good afternoon, Your Honors. Dan Ellis on behalf of the appellant. May it please the court. At the lower court, dismissed this claim, saying that there was a lack of personal jurisdiction as to the defendant's Diocese of Burlington. That decision primarily relied on the Eduardo decision, which was a federal district court case. Subsequent to the lower court's decision, this court issued its decision in PC 16-0, which I believe supports a finding of personal jurisdiction against the defendant Diocese of Burlington here. What we are seeking is personal jurisdiction under CPLR 302A. And the courts have held that jurisdiction is proper even though the defendant never enters New York, so long as the defendant's activities here were purposeful and there's a substantial relationship between the transaction and the claim asserted. What we have in this case is a priest, Leo Corsi, who was caught molesting children in the Diocese of Burlington. In response, the diocese sent him to a residential treatment facility, which Catholic dioceses across the country send priests who are accused of pedophilia.
And then sent him to the Bronx.
Correct. And to other dioceses in the state of New York. We hold that those activities in approving his employment in the state of New York were purposeful activities, and there's a substantial relationship between those affirmative actions and the claim that plaintiff brings here today. What the case law discusses is that what's important is the quality of contacts between the out-of-state.
So how long was he in the Bronx and in New York?
In the state of New York, in general, he was there for about 13 years, from about 1980 until 1993. I don't know exactly how much of that was in the Bronx. Our client was...
But in the state of New York,
the state of New York was for 13 years in total.
Because PC 16, if I recall correctly, because I believe I was on that bench, it was Carnegie Hall. It was one visit to Carnegie Hall.
That's correct. That was one trip to New York. Here, and it's important to understand the relationship between the diocese and a priest. It's a much more unique employer relationship because the diocese itself can not only control where a priest works, but whether a priest works anywhere in the country.
We're talking about the Diocese of Burlington, or are we talking about the Diocese of New York?
The Diocese of Burlington, Your Honor.
So Burlington sends him or transfers him to New York.
Well, there's dispute in the case over whether or not he was sent there.
Well, I couldn't figure out how he got here. I mean, it wasn't like he decides, oh, I want to leave this parish in Burlington, so I'm going to go to a parish in the Bronx. I mean, I'm assuming that there has to be some type of relationship or some type of communication. I don't think a priest can just show up like a judge. I can't just show up in New Jersey and say, hey, I don't want to use Jersey. I can't just, I mean, I can't just show up in another jurisdiction and say, hey, I want to be a judge here. So I would think the same thing with a priest, that there has to be some kind of communications. There has to be some type of arrangement in terms of payroll, because priests are paid. They do draw a salary. So I'm assuming there's some relationship there in terms of how they're drawing their salary, benefits, et cetera.
Correct. Father Corsi was incarnated within the Diocese of Burlington. After he exited that residential treatment facility, he tried to return to the Diocese of Burlington. What the diocese said is, you could work anywhere, but it can't be with us. So Father Corsi set out to find his own other parishes that will take him in. He is only able to work in an outside diocese with the express permission of the bishop of the Diocese of Burlington. And that's what happened here. The record demonstrates multiple instances of the Diocese of Burlington granting permission for him to work in New York parishes.
Even though he did everything on his own, ultimately, the boss has to say it's okay.
That's correct. It has to be with approval of the
He may
bishop.
not have participated in his, employment search, but in the end, you still have to go back and get the approval. You can't.
That's correct. And what's important is, at any point, the Diocese of Burlington could have revoked his faculties to act as a priest. It also could have initiated the process to have him laicized, meaning he's no longer a priest. It chose not to do that, specifically to avoid the scandal that would come with removing a priest for sexually abusing children.
But we have 13 years in New York. So, I mean, 13 years in another state.
That's correct, but he remained the diocese remained the employer of Father Corsi the entire time. And in fact, in 1993, the diocese exercised their right to revoke his faculties.
They finally revoked them.
Finally in 1993, Your Honor.
What's the minimum contacts? Quickly, what's the minimum contacts?
The minimum contacts here are the affirmations of employment, that approving his employment in the state of New York repeatedly. So if there's no further questions, thank you, Your Honor.
Good afternoon, Your Honors. Joel Iannuzzi for the Diocese of Burlington. In fact, Father Corsi was outside of the diocese for a total of 32 years, 17 years in 6 different states before actually going to New York, where he was there approximately 15 years. It's very...
Do you dispute that he needed the consent, though, of Burlington to be at these different places?
Under canon law, he needed the consent on many of those occasions. Consent was never asked for, consent was never given, only on certain occasions. Father Corsi, once he was told...
Only on certain occasions. So do we know on those certain occasions, were the New York, were the consents given for New York?
One of the New York consents was done post hoc. In other words, there was a letter from the Diocese of New York saying, hey, we've had this guy for a couple of years. Is it okay if he remains here? So the original consent was never given. It was really hit or miss in terms of whether...
That ultimately, the post hoc, I mean, they knew with all the things that were going on, they still consented, right? I mean, right? It's like, right? The stuff's,
No, you're absolutely right.
But see, like, it's not clear, the table's not clean, but okay, we'll consent.
No, you're absolutely right, but this is not a merits argument. The argument,
it's not.
The argument on appeal is whether the Diocese of Burlington, under the statute, is transacting business, and that's the only issue on this appeal, not merits.
Know that he was in New York, acting as a priest in New York during this period?
At some point, they learned, as I said before, they got a letter from the Archdiocese.
Did they have the ability to say, no, he shouldn't be a priest there based on his past history, and there should not be?
Of course they did, but then that's a merits argument. It's not a transacting business under the statute.
Well, why not revoke him?
Again,
as soon as sex abuse is found in Vermont, why not revoke him? Why wait till 1993 to revoke him?
Because
That shows they have authority over him.
there's no question they have overall authority, but the man worked 32 years outside of Vermont. They did not pay him. They did not house him. They
They
did
did
not
not
pay his
pay him?
expenses.
He's still not drawing
No.
a salary? So
No.
where's he?
He gets paid wherever he finds a job. And you were indicating, you know, a judge can't go from one place to another. Priests can. They can go anywhere they want. They can knock on a door and say, I'd like to serve here. And if they say okay, the only issue is going back to the bishop from the
getting back
original
to
place
three-
and saying, will you consent to this?
Getting back to 302, right? The
Yes,
transacting
yeah,
business
that's the
here, right?
issue.
So my thing is that, you know, at one point, you may argue, okay, we never knew, the Burlington diocese never knew he was in New York, or at least, you know, we had no saying whether or not he's in New York. But at some point, there was one transaction which occurred, which was the post hoc thing where they asked, you know, can we get his consent? Should we continue? Yeah, okay, we consent. Doesn't that enough to trigger 302A?
Well, that's the question. Is that transacting business?
Well, I think we held in PC 16 that it is.
Well, PC 16 was different because PC 16 Doe was a case where the diocese actually arranged and set up the trip itself. So they were very involved in not only in setting up the trip, but supervising the trip for which the abuse occurred.
That's a distinction without a difference, because as my colleague pointed out, the Burlington Diocese knew of this priest's issues with this priest already when they did that post hoc consent, right? I mean, at that point, unless I'm mistaken, did they not know? I mean, there was no information at that point?
Even if they did, again, that's a merits argument.
It's a merits argument, but that may have figured into the transaction analysis, don't you think?
The transaction analysis, I'm not sure I follow the question. The analysis is, are they transacting business? And is there actually a back and forth between these two entities? The one actual contact is, at some point, New York, there are 6 different states that he actually,
Counsel, they're the only ones who have the power to remove him from
no.
the priesthood?
Well, they can, any of the dioceses who were hiring him at that time could terminate him.
From
They
that
can't
particular
can't
job,
remove
but
him, right.
is the Diocese of Burlington the only one who could ultimately remove him from his ability to be a priesthood?
That's right. That's exactly
So
right.
as long as they did not exercise their authority to remove him from being a priesthood, they knew and were aware that he could continue getting jobs in other places and continue acting as a priest. And it was in their control whether or not he ultimately stopped acting as a priest somewhere. Is that?
And I agree 100% with that, except that's a merits argument.
The question is whether or not
Are they
that single-
transacting business?
the question then, I mean, if I'm hearing you, whether or not that post hoc consent is considered, falls within 302A.
That-
Right,
302A.
and so that
302A,
was my statement in terms of PC 16 Doe, that the one contact that we found was the recital or whatever it was at Carnegie Hall. And you're saying that there's a distinction here because in that particular case, the diocese arranged it, right?
Yes.
And so that there's a distinction. Go ahead.
Yeah, and in PC 16, this court actually distinguished between what happened at PC 16 Doe versus Eduardo, and basically carved out and said Eduardo is not a situation for which there is contacts. Eduardo is very similar to our case. That's my point, is that this court distinguished those two cases, and if you look at the facts, our facts are very similar to Eduardo because we had, at the time, the abuse happened at a completely different location, at a completely different time, exactly the fact pattern under Eduardo.
Well, see, the only thing is that Eduardo, the distinction I see between Eduardo and this case is the fact that we do have Burlington at some point, although it's afterwards, consenting to his remaining in New York or his being in New York.
Absolutely, but the question is that transacting business? And I don't think under the transacting business, case law, for instance, there are two, and I'll just finish up quickly, the two Court of Appeals cases, Etra and Paterno. In Etra, there was a Massachusetts doctor who sent experimental drugs to New York and then acted as a consultant to the New York doctor. New York Court of Appeals said, no, not transacting business. In the Paterno case, which is a case been cited extensively in this case, online ads and pre and post surgical contacts with the New York consumer, New York Court of Appeals said, no, that's not transacting business. The level of transacting business here, of course, he went out on his own for 32 years, found jobs, and the only connection is at some point they approved it. Again, it's not a merits issue.
So how do you respond to the plaintiff's submission of the 1985 edition of the Official Catholic Directory, which shows that Father Kersey's assigned to the Diocese of Burlington and on duty outside. Doesn't that show that he's working for the diocese and therefore?
It doesn't
I'll
show,
hear you.
no, it doesn't show that he's working for the diocese because he never worked for the diocese for 32 years. He was outside the state. He was never paid. He was never provided transportation. He was never provided housing.
So
No
this is
benefits at
nothing.
all.
This 1985, we shouldn't consider it.
No, you should consider it because he is assigned, because once he's with the diocese, once you're incarnated in a particular diocese, you're there for life, right?
Counsel, so then once Vermont finds out what he did, they could have revoked him right then and there.
And I don't disagree with you, except that that's a merits argument. It's not an argument on 302A1.
Thank you.
One thing I'd like to address is,
So what do you got that post hoc consent? If that's what you got, what else do you have that you can sort of weave into that tells that it's transacting business, like the case that we were talking about here?
right, what I want to correct is that the post hoc, there's actually many correspondence in the record giving consent for Father Corsi to continue. The post hoc related to his time with the Archdiocese of New York. He was given express permission to practice within the Diocese of Brooklyn. And my understanding from the record is that was not post hoc. That permission was sought out by Father Corsi.
In my mind, if you got more than one, that's good, right? I mean, then you're transacting business, right? I mean, that's what he's, the way I understood it, was only this post hoc consent. But if you're saying, no, wait a minute, there's another consent going on too for the Brooklyn Diocese, that's two, right? So.
Right, I don't think it's a scenario where you need more than one. I think one is enough. They knew he was in New York. They continued to grant him permission to continue serving with children in the state of New York. At any point, they could have revoked it. They had control over him the entire time he was in New York and for the entire 32 years he was outside of Vermont.
Still, we're just talking about the transacting business, right? So what about Eduardo? How does that figure into the equation?
Right. So I think what the respondent's trying to do is treat this as a case of a for-profit entity. And really, the relationship between a diocese and a priest is much different. They control everything about what he's allowed to do, no matter where he is in the country. Eduardo, the connection between the out-of-state defendant and the state was much more tenuous. The trip to New York there was to obtain exculpatory evidence for some type of criminal defendant and to solicit a donation. Eduardo's a case where all of the abuse took place in Rhode Island. It was a Rhode Island parishioner who was abused. It's completely different than the facts here where he arrived.
Actually, Monsignor McDermott, in his affidavit, he really didn't describe or go into the sort of things that you're talking about here in terms of what the relationships were, or what's going on. It was more very sort of, the information he was giving was more business side information rather than the relationship between the priest and the diocese, and what the relationships is, and and whether or not would go towards whether or not we can determine there was transacting business, right? I mean, he didn't say anything in his affidavit. My notes are saying that.
Yeah, that's correct, Your Honor. They completely ignore the relationship between the diocese and the priest here because they can't get around the fact that he was their employee the entire time. They had control of him the entire time, and they could have revoked his privileges whenever they decided to.
Thank you. Thank you both. American Pipe v. National Union. You may proceed.
Good afternoon. Thomas Leghorn for the appellant, defendant, third-party plaintiff.
It's a hot mess. It's a hot mess, this one.
Yes, it makes me think back to civil procedure and figuring out all the flow charts.
You need a flow chart to figure out who's on
Yes.
first.
So I usually get up here and tell you what the appeal is about, but I think I should start by saying this is not an appeal about trying to overcome the irrefutable presumption of the insurance law. What it is about is that the determination by the court below was based on insufficient evidence to invoke that presumption, and it was woefully premature. My client got brought into this action as a third-party defendant. As the proceedings were going on, but before any discovery was being done. What triggered the motion by Scottsdale was an admission in the pleading of the plaintiff, American Pipe, that they had not given notice to Scottsdale. But that wasn't the only party involved in this complicated chain of insurance that American Pipe had in place. First of all, the accident occurred at a New York City Housing Authority site, and they too were on the certificate of insurance as an additional insured, and they too had the ability and right, an obligation.
Counsel, let's cut to the chase.
Excuse me?
Let's cut to the chase.
Sure.
So you have notice provided to the insurer 4 years post-accident, 3 years after the PI case is commenced by Fortune, the person who was injured, and then it's 10 months post-verdict. So it's a mess. How do you deal with insurance law 3420C2B, which says an irrebuttable presumption of prejudice shall apply if the liability of the insured has been determined by a court, binding arbitration or settlement? How do you get around that?
How do I get around that is because in the position my client was placed in, I don't know the truth of any of these statements. The motion for summary judgment stayed discovery. We came in, we propounded discovery. None of it was responded to because of the stay in place. What we have from Scottsdale
What about the 10 months after verdict? What about the delay in moving forward?
Whose delay in moving forward?
You tell me. So at what point after verdict, how much time after verdict does your client say, oh my goodness, let me intervene, let me try to undo all of this mess?
My client?
Yep.
My client's first notice of this issue is when they get sued for it. They're not brought into it because my client, they placed the insurance, this tower of insurance, the 3 insurance, AmTrust, Scottsdale, National Union, and then during the currency of that policy, but before the incident at question, they were moved as the broker of record. There is another broker put in. It has taken me until about 2 months ago to find out who that broker was. So there's been no delay on our side. We were taken out of the transaction. All of this transpires without our knowledge. We get sued. That's when we
I'm
find.
going to interrupt just to ask you about a question that was not raised by the parties, but that we have to consider as a jurisdictional predicate to consider the appeal. At this point, the case was dismissed against Scottsdale, and plaintiff did not appeal that. And the case has also been discontinued without prejudice against your client. So how is your client now an aggrieved party in such a way that it will allow you to have this appeal heard? Because although it's clear it might later become relevant down the line why Scottsdale was not dismissed in terms of your client's liability, at this point, there's no case pending against your client.
Yes, I anticipate
We have to resolve that issue before we can address the merits.
We do. And this was something that was brought up with the trial judge because what I learned at the oral argument, because being brought in so late, was that National Union had stepped in and paid Scottsdale's, so as not to leave their insured exposed to this judgment that they were above.
Your National Union paid the $2 million.
They paid Scottsdale's 1 million gap.
Okay,
They
yeah.
paid Scottsdale's, and now, so National Union had sued American Pipe to say, I need to be made whole. I filled the gap for you. But to answer your direct question, it was, American Pipe had tried to discontinue this action. And I learned of this other action, which it was, well, if things go well with American Pipe in Scottsdale and I win there.
Ultimately,
I'm sorry.
So you
Wait, I
didn't.
want to hear the answer to
Yeah,
the
what's the
question.
answer to the question?
The judge should have consolidated the two actions then and there. Because as I pointed out to the court,
But if they weren't consolidated, which they weren't, at this point, although those issues may get litigated in this other action, which I don't know about it, but they may get litigated in another action, I don't see how they can get litigated. I don't see how you could proceed with this appeal and this action since they're not consolidated
well,
now, because we have the record as we have it.
Well, I think for the, interests of justice and judicial economy.
Well, we can't even do judicial economy. I mean, we would like to be, economic, I guess, efficient, but it's not on the record before us. That's it. That's the problem.
Well, it's on the record before you in terms of pointing out that the other action is
But how are
pending
you
in
an
the same,
aggrieved party in this lawsuit, which is all we have before us? We don't have the other lawsuit before us. What possible argument could there be that you are an aggrieved party in this lawsuit?
I'm an aggrieved party in this lawsuit because I don't know for a fact whether American Pipe's records show whatever. And I'm being,
The other lawsuit that you're going to be litigating.
but Scottsdale is the one that has been released. And
But this case is over in that sense because, if you ask us, the way I look at it, and as my colleagues correctly pointing out, whatever ruling we give you here, you're not an aggrieved party, but then it's going to affect the pending action. There's still an action pending that National Union has, right?
And I understand exactly your question, but I am an aggrieved party because I'm being called upon, my client's being called upon to make up the loss.
Not in this case.
Not in this case.
Yes, they were. We were third
But
party.
right
there.
now, you have been, there's no claim against you now in this case that's existing right at this moment. What is the direct claim against you right now in this case that our appeal would resolve in this case?
I would be happy if I was dismissed out completely, but the court did not do that. The court, for expediency.
So what claim currently exists against you in this case?
At this point, nothing, and that's why I'm appealing. Because
if there's no claim that exists against you, what are you appealing?
what I'm appealing is that the court let Scottsdale out too soon without the proper evidentiary basis for it and without discovery.
But you have to show that because of that, there's some harm to you, or that causes some harm to you.
Right.
And I don't see where you've shown the harm that caused to you.
I am still being sued for that $1 million loss.
In
Not
another
here.
case.
In another case.
Right, and that's where you have to go litigate the issue.
Thank you. Thank you. You have time on me, Beto.
Thank you.
Good afternoon. Ann Odelson, Kennedy, Scottsdale. Briefly, the procedural posture is
Hot mess.
hot mess. But he had a cross-claim against Scottsdale. So even though American Pipe, who's our insured, who's required to provide us with notice, admitted repeatedly in the complaint they didn't provide us with notice, even though there's emails with his client and AIG who sat above us saying, did someone let Scottsdale know? And then they told us after there was a judgment and 4 years after the incident.
You're arguing the merits now, though, right?
But I guess my thing is, there was still the cross-claim against me. So the judge decided we would basically rule on the merits of his cross-claim against me, knowing that there's another action that they're seeking to bring me back to the table. And so we wanted to be out of it, and we said, so because of the cross-claim.
Wait, so what, I'm sorry.
So because it was a hot mess, but everybody was like, we're going to go litigate this. American Pipe, the insured, agreed to discontinue against Scottsdale and the other parties, but Appellant had a cross-claim against me for
What happened to that
contribution.
cross-claim?
So I wanted to be done with it because I knew his cross-claim was alive against me. He was going to seek contribution from me. I don't know procedurally how the court.
So what happened to the cross-claim?
It's dismissed because the court addressed it and discontinued the action against me when they found out and decided, based on the evidence, that we.
It's not a ruling, though, really.
I'm sorry?
I'm sorry, that's not really, it doesn't sound like a ruling about the
But if the
cross-claim.
court considers his cross-claim, that could have been still remaining if that action even went away, his cross-claim for contribution against me, which the court decided in its decision where it found that we provided a timely disclaimer, Lotus was
I'm
late.
sorry, the court didn't make any explicit finding that the cross-claim was dismissed?
In the decision, it says the cross-claim against me is discontinued with prejudice, and there's a footnote.
Discontinued with, how can it be discontinued without prejudice if they didn't move to discontinue?
There's a footnote in the court's decision where the judge addressed it, addressed the discontinuance with prejudice of the claim.
They discontinued their cross-claim without them requesting it be discontinued?
No, the footnote
Yeah.
is,
It
Scottsdale
says,
takes a position that, based on the motion, the matter should be dismissed with prejudices against Scottsdale. For the reasons in this decision, the court sides with Scottsdale, so dismissed it. It didn't discontinue the cross-claim.
I'm sorry, dismiss
It dismissed
the
the cross-
action, which included the cross-claims
Right.
against me with
So-
prejudice.
So
Sorry.
essentially, then, it sounds like he's been aggrieved because his cross-claim against you was dismissed.
Yes, he's been aggrieved, but he doesn't get the discovery that he wants because his whole position is, even though
It
we.
doesn't matter, for our purposes, it gets over our jurisdictional
Yes.
quandary because he has a dismissal. You should have said that. Your cross-claim was dismissed. That's how you got aggrieved.
But,
So that's undisputed, that.
so
that-
if
that-
he's
wait,
aggrieved.
So wait,
I
one
just want to make
second,
sure
one
before we
second.
go to the merits.
Yes,
It's undisputed that the cross-claim that his client had was dismissed on the merits, so he is aggrieved, his client, and there is an appealable order, and we should decide this case on the merits.
Yes.
Not on the ground of a non-appealable order.
yes,
Right.
yes.
And it was dismissed with prejudice?
Yes.
Yes, okay.
Okay.
Got it.
So the bottom line is, on that one, is we showed, when Scottsdale got notice, the email chain shows it was starting in 2016 when someone was like, who's the next layer after the primary policy? It's Scottsdale. AIG was above it. At some point in November 2020, someone said, did someone put Scottsdale on notice? And it was like, oh, now we need
Based
to put
on
them.
the record evidence of just
Yes.
the email chain itself, come on.
Exactly.
We didn't get noticed till way after.
Exactly. And so the court said, we showed, there's no issues of fact as we got it. The whole thing, maybe someday, somewhere, someone's out there, maybe they provided them with notice. It's not an up to
It's not
date.
yet, but that's not your problem.
Thank you.
Just could, 1 second, the issue in terms of discovery. They're also claiming, right, that they need additional discovery from you?
They didn't provide us with notice, and all the other parties could have yelled at me during that motion, and they didn't. There's no, it's like a mere hope that maybe somebody did when we showed this was based on the email string. We got notice in December 2nd, 2020, but that was after a judgment had been entered, a verdict. Liability was dead in the water on that point.
Thank you. You should have mentioned the cross.
I should have, you know.
You didn't.
Oh,
You
man.
kept saying you were agreeing,
I
but
was
we
so
could figure
tied
out
up
how
in
you
the other
agreed.
argument, I missed it. And so I'll be very brief in repayment. As to the discovery there, it was, we propounded the discovery on Scottsdale. And all that was put forward to support the motion was the affidavit of someone in their records department or whatever, who said on the business records, whatever. But we never saw all the business records. We didn't see the files that we asked for. So we don't know if that's the full scope of it. And you know what? Scottsdale, at the end of the day, may be absolutely right, but we just don't know. And it was premature, and therefore on the 3212F, we didn't have access to the information in the hands of others to properly respond to the motion. And that's all I have to say unless you have anything further.
Thank you. Thank you both.
Thank you.
People v. Benjamin Ornstein.
Good afternoon. Legal Aid Society by Everett Hopkins for Mr. Ornstein. Your Honors, this court should vacate Mr. Ornstein's sentence and or dismiss the matters under court number ending in 558 because the drug treatment program was unable to manage Mr. Ornstein's mental health needs. And additionally, when the court was made aware of this, the court failed to do an inquiry or to offer plea withdrawal or an opportunity to complete the program at a more suitable location.
Does the record reflect that the defendant needed urgent medical or psychiatric care?
It reflected that he needed psychiatric care.
How?
There was a evaluation done prior to him being sent to the program that the court had ordered. The court ordered this evaluation because it knew full well that he had some severe mental health issues.
He was 730'd?
I don't believe there was a record that he was 730, no, Your Honor. But he has a long childhood history of being diagnosed with certain depression disorders, which were all outlined in the evaluation as well. He was diagnosed with several mood disorders and substance abuse disorders. So now what I should note is that there's nothing in the record to indicate that the court confirmed with the program that they were going to be able to handle these diagnoses. That report laid out also recommendations for the program to follow so that when he got to the program, he would have a reasonable opportunity to handle his addiction. So those recommendations included psychological care, which included therapy, regular meetings with a psychiatrist, and he stay on his medications. However, when Mr. Ornstein arrived at the program, he was told that there was no medication there for him, there was no medical staff on site, and there were no psychiatrists there.
Correct me if I'm wrong, but I thought there were two conditions to this. One was to remain in the program, and if he did not remain in the program, it would be 2 to 4. And then the other condition was he not be rearrested, and if he did get rearrested, it would be 3.5 to 7.
Correct.
And my understanding of the record here is that he was rearrested, and that was the basis for the court imposing. The court did not impose a 3.5 to 7, instead imposed a 2 to 4.
Right.
So I'm hearing what you're saying about the program, the alleged inadequacies of the program, but it was basic. And I've read the sentence. If I read the court's, what the court was saying was that it was based on the rearrest, and not because he didn't finish the program.
Well, I mean, the court said that it was based on the contract signing and the rearrest. So based on the contract signing, our interpretation is that that means that he, didn't finish the program as well. So I think it's on both.
If the program was unsuitable, it's undisputed that he was rearrested, that he violated the condition of the plea, and therefore it was appropriate for the court to sentence him regardless of whether the program was a good program or not.
Respectfully disagree, Judge. It was actually inappropriate for the court to sentence him without offering him plea withdrawal or an opportunity to complete.
My reading of the record was that he was supposed to be in a 24-month inpatient program.
Correct.
If he successfully completed the program, the charges would be dismissed.
Correct.
Okay. He left the program, I thought, within a couple of days, right?
He was discharged from the program in about 9 days.
Within
about 9 days of him being arrived there. But this is what we know, Your Honors. First of all, this court has said several times in other cases, implicit in every promise of drug treatment is that the defendant will have a reasonable opportunity to deal with his addiction. That did not happen in this case.
Okay, so he signed. This was a special part, right? This is the MDC, right?
Right.
So you talk about a contract. There's a handbook that they have, that they use, that they give individuals. They sign the contract. They are made aware of what is required of them. He signed that contract. He was made aware of it, and he was discharged from the program.
That's correct, Your Honor, but that doesn't relieve the court of its duty to make sure that they are giving him a reasonable opportunity in a suitable facility to deal with his addiction.
Okay, so the program is selected in conjunction with the court and the the program staff. They find a program for him. He
Correct.
cannot leave. They make a determination as to whether the program is suitable or not.
Presumably so, Your Honor. But again, like I said, there's nothing in the record to indicate that the program was ever able to affirm that they were able to abide by these
The
recommendations.
fact that he was selected, the fact that that particular program was selected means that it was a suitable program for him. But we're kind of putting the cart before the horse, because don't we have to deal with the waiver of the right to appeal?
Not in regards to my first point, Your Honor. With regards to the second point, which is my excessive sentence argument, yes, you would have to deal with the waiver of appeal, which I've indicated that
Okay,
it's...
so then I'll go back to the sentencing. At the time that he was brought back because he was discharged from the program and he was going to be sentenced, was there any statement by his attorney that there should be, that the program was inadequate, or that he should be given a second chance, or anything like that?
Mr. Ornstein went on for about 2 or 3 pages in the sentencing about how the program basically did nothing for him. When he got there was no medical staff on site to treat him. He asked for his medication several times. He didn't receive any. He didn't receive any therapy.
Was there any statement that by his attorney, we need to find another program for him or give him another chance?
No, there was no statement by his attorney. However, the burden, again, lies solely at the court's feet. Upon hearing these statements...
The burden is on the court?
The burden is on the court to
I never heard that the burden was on the court.
Well, to conduct an inquiry into what Mr. Ornstein was saying about the program being
Even if the
inadequate.
attorney is not requesting that the defendant be given a second chance, or that the defendant, or that there are reasons why another program should be found that's going to be suitable for his needs?
Your Honor, this is all based on the cases from this court: People v. Cruz, People v. Feliciano, People v.
People
Rodriguez.
v. Feliciano. I happen to know that case because I happen to have been the trial judge in that case.
Ah, okay.
I was a sentencing judge in that case, and this court, for some reason, reversed me because, and I will not forget that, because I did not give Ms. Feliciano a second chance. Although she had a third chance. I think it was actually a third chance. I didn't give her a third chance. But that was my point, because in this particular case, I did not see anything in the record where this attorney requested another program. It was like, we're ready for sentencing.
Well, let me point you to a Court of Appeals case, then People v. Fiametta. I hope I'm pronouncing that correctly. But basically, what the court says is that the court has a duty to at least inquire, right? They have a duty to at least carry out an inquiry in sufficient depth to satisfy itself that there was a legitimate basis for the removal or the violation within that program. So, and it talks about how it's, the court has to explain on record its inquiry, its conclusions, and the basis for them, and that this
Counsel,
arises...
going back to my colleague's question, the discharge occurs because the defendant allegedly took a picture off the wall and threatened a peer with the picture during a verbal alteration. Am I right?
That's right. So
are you saying that, notwithstanding the fact that counsel did not request an inquiry or offer an explanation, the court was required to inquire as to what happened and how come he took a picture off the wall and threatened to hit somebody with it?
Well, I think 2 things, Your Honors. First of all, there's nothing showing that counsel was even aware of these allegations, if I can finish up briefly. What happened is that once the court heard...
Allegations concerning his client?
Correct. So what I'll say is that it seems that at some point, I believe it was in June, the program had sent a letter to the court indicating that he was discharged. Now, from that record, I believe respondent did submit that into the filing. It's a 1-page transcript where it shows, it doesn't show who's there. It just says the court is reading a letter in as to the allegations as to why Mr. Ornstein was removed. I don't see anything where defense counsel was made aware of that letter or anything like that. So I don't know if defense counsel actually knew the actual basis for his removal. I think all that's clear is that he was removed from the program.
Seemed to be ineffective assistance of counsel. But you have time on rebuttal.
Thank you.
Good afternoon, and may it please the court, Faith Petrolio for the people. Defendant's conviction should be affirmed. Defendant was properly sentenced after he failed to abide by the terms of his plea agreement, namely to not be rearrested. Defendant's contention that the court failed to properly inquire into his basis into the basis for his removal.
I'm looking at the transcript here, and I think counsel is looking at this, the provision of the sentence, what the court says, based on the new arrest and based upon the contract signing, the sentence of the court is 2 to 4 consecutive to 2 to 4, right? So that sort of roping in the contract signing is where counsel is arguing, well, you know what? There was an obligation on the court to do a further inquiry as to whether or not the program was meeting his needs, right? But the way I look at it is that, you know, he starts off by saying based on the new arrest. I mean, I think all the cases that are being cited didn't have that other component where there was another condition that was violated for the court to give the sentence that it did.
I would agree with that, Your Honor. I would also add that based on the contract signing, the contract also included the length of the sentences that would be imposed based on the violation.
Well, that's the basis for the court to give the sentence.
Exactly, exactly.
And the people did inform the court of the new arrest and said that they would not consent to further drug treatment, correct?
That's correct, Your Honor. Yes. So given the fact that defendant had violated that independent ground of his plea agreement, there was no further inquiry that was required. The arrest was undisputed. The validity of that arrest was undisputed, and it's clear from the record that defendant was, as Your Honor had noted, that defendant was being sentenced for that violation and not for his termination from the program.
I mean, looking at this transcript, even when the defendant was making his statement to the court, I mean, I don't think counsel mentioned that there was a problem with the program. I mean, after he finished his statement, that was it. Didn't get any further, didn't give the court any reason to make a further inquiry.
Yeah, I would agree with that as well, Your Honor. Defense counsel never said to the court, you know, he's raising some issues, maybe we should have a further inquiry into this. I think everyone was on the same page. And I think everyone was well aware of the circumstances of his removal from the program, as well as the circumstances of his new arrest.
So you argue that that issue was not preserved because it was not mentioned at the time of sentencing?
Correct. A defense counsel or defendant never, pointed the court that a further inquiry was needed, or that maybe we should talk to someone from the program to see if it was suitable for him or not. No one ever asked for another program for him. So on that basis, we would say that that contention is unpreserved.
Would you kindly address the appeal waiver? It appears that the appellant's rights were addressed only during the 1605 and not during the 211. So is the court able to do a twofer? In other words, you do an appeal waiver once and it applies to every case?
Your Honor, he did plead to both the indictment and the SCI in the one proceeding in this case, and I believe he did sign 2 separate waivers of appeal, if my memory serves
I'm
me.
talking about being informed that he would normally have the right to appeal, being asked whether he understood his appellate rights, the waiver of his appellate rights.
Yes.
Being asked whether he understood the written waiver form. So that was asked as to one, but not to the other. Can you do that? Can the court do that?
I would say in this scenario, since defendant knew he was pleading to both on the same day at the same proceeding, and he was well aware of the fact that he was waiving his right to appeal for both, and additionally, I believe he signed 2 separate waivers for both the 211 and the 1605. I think in that scenario and with these set of facts, it is clear that he was waiving his right to appeal for both of those.
I'm sorry, so he pled to 2 counts of grand larceny in the 3rd degree?
Yes.
And that was for the program, right?
Yes.
And then the new arrest was the attempt burglary.
Attempt burglary and...
Right, so when he's pleading guilty to the 2 counts of the grand larceny, there's 1 waiver.
There was one, I think there was one waiver colloquy, but there was 2 written waivers, if my
Right,
memory serves
exactly,
me.
because he's pleading to 2 counts at the same time.
Correct.
The excessive sentence, we're talking about 5.5 to 11.
Yes.
So 5.5 to 11 years for 2 counts of grand larceny and an attempt burglary. Is that excessive?
No, Your Honor. Defendant was given significant leniency in this case. He was sentenced the minimum on all of the
Sorry,
counts.
defendant was what?
Given,
Could you just
hear you.
keep
oh,
your
I'm,
voice
sorry,
up?
I'm sorry.
That's okay.
Defendant was given significant leniency in this case. He was given the minimum on all of the counts.
But it's consecutive.
Yes, Your Honor. We would argue that that the sentence is fair and appropriate given defendant's lengthy criminal history and the opportunity that he was given to get a complete dismissal of 2 of these cases. They wouldn't be running consecutively because they would have been dismissed at this point. And all the mitigating factors were considered by the sentencing court. If there are no further questions, we ask that you affirm.
Thank you.
Thank you.
Just briefly, Your Honors. So I just want to be clear that simply because defense counsel didn't say anything about another opportunity for a program or anything doesn't waive this right, doesn't waive the issue of the court having a duty to offer plea withdrawal upon Mr. Ornstein objecting, saying that this program is not suitable for him.
I don't know of any case that says that that is within the purview or something that a court should do, where a defendant does not meet his responsibilities when you're talking about a program. There was nothing in the offer or anything that said, but if you fail to complete the program and you are terminated from the program, you can withdraw your plea. That's not something that's said.
No, of course not, Your Honor. It's not in the contract, but it's implicit in every promise of drug treatment
No,
program,
it is not.
which is what
There's nothing. I mean, what is implicit is that if you do not meet your responsibilities in terms of remaining in the program, you are going to be sentenced to 2 to 4 or whatever. It is not. There's not a plan B where, or you can withdraw your plea. That's not there.
if the program was suitable. If it's not a suitable program, this court has said that he should have been offered plea withdrawal or an opportunity at another location to complete his treatment.
What case is that?
The cases I had mentioned.
The Court of Appeals case, that's not what it says. It says that if requested by counsel, or if there's some argument by counsel.
Right, but it also does show that the court has a duty to inquire as to the nature of the removal, and the court failed to do that here. And just briefly, Your Honors, with regards to the appeal waivers, although he did sign the waivers, 2 of the waivers, the court, it's clear that they never examined the waivers to determine whether his rights were waived knowingly and intelligently. Additionally, I think the court had mischaracterized the appeal waivers as saying that normally this plea is final and that he can't take it back, which is obviously a mischaracterization. And I think it's important, given Mr. Ornstein's history, that the court be especially clear here. So you can't.
Given his history in terms of
mental
the
health and
numerous
substance abuse.
prior convictions, or given his history in terms of what you term as his mental health issues?
Mental health and substance abuse issues, correct.
Thank you. Thank you both.
Thank you, Judge. Thank you. Take care. Good job, counsel.